The hearsay evidence, but I was informed that my colleague, Mr. Moyeng, was admitted in hospital and he's not present today. There's also no one from legal aid to stand in for him, my lord, and under that circumstances I would request that the matter be rolled till the 26th of April. The accused is in custody, is present in court.
Insane? Where is the accused?
He's sitting in the one with the red on the right hand side, my lord.
Will you rise up?
red jacket.
Well, in this case, I was to deliver a ruling on the admissibility of hearsay evidence. Your legal representative, Mr. Mweng, is not available today. We are told that he is admitted in hospital. A date has been agreed upon, and as a result, the case is postponed with you in custody to the 26th of April 2022.
Court, please. May I be excused, my lord?
The next matter, the matter of the State versus Vosloorus, case number 6667/2020.
This is my lord. My lord, I don't see the counsel for the state in our.
Yeah, I think she called the matter too quickly.
Thank
I
you.
don't know what the delay is, and maybe when the state advocate arrives, maybe we should talk about starting in time or maybe even starting earlier, because if we go on this rate, there won't be progress.
That's the court.
I don't know, are you not able to contact him so that we can
He
establish
was
what?
here, he went to pick up some files.
Okay.
He was here earlier on, my lord.
Yeah, in any case, we are not starting in good time. And I think we should not continue on this rate.
That's the court.
The court pleases. Appear for the state. Apologies, my lord. I quickly had to go get some files. Let the court please, my lord. I confirm my representation for accused 1 up to 4. It's Advocate MD Tefu, briefed by TT Tobani attorneys.
My lord, I confirm appearances on behalf of accused number 5, Mshololo initial Z. The court pleases.
As the court pleases, my lord, watching brief from Ms. Kelly Kumala Magdalene Mansano.
Before we proceed, Advocate Baloyi, my thinking is that maybe we should agree on starting time.
Indeed, my lord.
I think what normally happens is we start at 10. However, if nobody is inconvenienced, we could determine an earlier time, like 9 or 9:30, provided nobody is hard done by that agreement.
Indeed, my lord, but subject to what will transpire shortly from the communication that I received from my colleague for accused number 5 just this morning, my lord.
Okay. Yes, let's proceed.
Yes, maybe I should just allow my learned friend for case number 5 to address the court. She just told me shortly before 10 that there are certain issues that she would like to bring to the attention of the court.
Yes.
The court pleases, my lord. Firstly, my lord, I would like to thank the Honorable Court for the indulgence that I was given yesterday for the adjournment to consult with accused number 5 yesterday. My lord, from our consultation yesterday, through the statements that were discovered on the 30th of March,
Yes.
it appeared, my lord, that we still need more particulars in order to be able to prepare our defense. The instruction, my lord, I got after going through the statements that were disclosed 2 weeks back are that we need, or we still need time. I beg my pardon, Your Worship.
Yes.
To verify information, my lord, contained in the statements from the defense witnesses who are not here in Pretoria and who are in KZN. And some of the defense witnesses also, my lord, are in Joburg, which we also still need time to verify further particulars from them to enable us to prepare our defense. There is also some information, my lord, that we're still going to request from the state, further and better particulars, as a result of the information contained from the statements that were withheld, my lord. Had we been given the statements, my lord, at least a month ago, we would have been in a position to proceed with this matter at this stage. My Lord, it is my submission further that accused number 5 will suffer prejudice if he is not afforded an opportunity to get or to obtain adequate information, adequate particulars from the state, as well as other defense witnesses, as I have just addressed His Lordship. My Lord, the information or the particulars that are outstanding on the side of the defense are the particulars that will enable accused number 5 to be able to formulate not only the defense but the plea explanation that has to be placed before this court from the outset of the trial. My Lord, without repeating the importance of Section 87 of the Criminal Procedure Act, and without repeating the emphasis, constitutional emphasis that is contained in the case of S versus Shabalala regarding the docket privilege and the furnishing of the further particulars, that has not been honored, that has not been complied with by the state in affording accused number 5 with an adequate opportunity to prepare for his trial.
If I can understand you clearly, this concerns information that the defense needs for purposes of the defense of accused number 5, but it is details that came into focus upon the defense receiving further statements. The further statements we spoke about yesterday. So it is not like the state from the onset withheld information.
Yes, my Lord.
The state provided information.
Yes.
The reality of the state was that some of the witnesses that are to feature have security issues that need to be taken care of,
Yes.
which dictated the timing of the state releasing the said statements, given the reality that releasing the statements would also lead to a revelation of the identity of the witnesses concerned. So in other words, it's not like there was information the state needed, the state knew to be needed, which it withheld. The state came to know that the information is now needed by the defense after the defense had sight of the statements that were released 2 weeks ago.
Correct, my lord. However, my lord, on top of the statements that were released late by the state, still the identity of those witnesses is hidden, my lord.
Yes.
And as a result, we do not see the reason why these statements were released so late. Because the identity is still not disclosed to us as of today. But we were able...
Well, that I think was well within the discretion of the state, because I mean, depending on the contents, you can write a statement and not append your name. You can even write it in somebody else's handwriting, but I may know which of the witnesses is capable of testifying on that kind of information. So I think the discretion about releasing the statements with considerations of the safety of the witnesses, I think was squarely within the court of the state.
My lord, I was just responding to his lordship regarding the identity of the witnesses.
Yes.
That it has still not been disclosed.
Yes.
However, that is not our issue. That is not our bone of contention, my lord. And we are not saying the state was wrong in doing that. Our main issue, my lord, is that since we have been given the opportunity, we got the opportunity only yesterday.
Yes.
With accused number 5.
I think you don't need to repeat that. I perfectly understand that.
Thank you, my lord. As a result of that,
yes,
we are unable to proceed, my lord, with the trial today. And we request, my lord, for a further 5 days so that we can be able to consult with these defense witnesses who are outside of this province, as well as those defense witnesses who are within the province, and then we'll be able to be ready with the trial. This trial, my lord, was set down from the 11th of April until the 29th of April. And we are not asking for the entire period of the session. Can I continue, my lord?
When you say 5 days, what do you mean? Are you talking about 5?
5 court days, my lord. 5 court days from the period that has been set down for this trial. Then we are asking for 5 days so that we can be able to prepare what I've just addressed His Lordship with, and then be able to come back on the 25th of April and be able to resume with the trial. I think I'll be repeating myself, Your Worship.
I think I need a calendar to be able to. Munseng, do you have a diary here? I don't understand how you go to the 25th.
25th is the Monday of the last week of the session, my lord.
No, what I'm saying is that 5 days, if you are saying 5 court days, we have tomorrow.
Yes, my lord.
Which is Wednesday. We have Thursday.
Yes, my lord.
That's 2 days. We have the 18th, which is the 3rd day. The 19th is the 4th day. The 20th is the 5th day.
20th. So it means we can resume on the 21st, Your Worship. My
Yes.
lord.
If you are talking 5 days, then the 21st would be subject to what the others are going to say.
As the court business, my lord.
The 21st will be beyond the 5 days you require.
Will be the 5th day.
Yeah.
Yes, my lord. As we have said that 1 day that we were given yesterday was not sufficient, my lord. And therefore we require another 5 days, 5 working days, my lord. Court working days. Then we'll be able to resume the trial, my lord. Those are my submissions, my lord. Thank you, my lord. My lord, can the interpretation be done to my client? If we do have a Zulu-speaking interpreter.
Certainly there is, my lord.
Thank you, my lord.
Mangalalela ne. Ummeli wakho ngoba nina qoqisana nobabili. Namhlanje ke uza nesicelo la kule nkundla yamaqala, uqala inkosi yenkantolo ukuthi leqala lapha malihlehliswe ngamalanga ayi-5 noma izinsuku eziyisihlanu. Uthi isizathu ngilezi ezilandelayo. Isizathu sokuqala ama-statement lawa yena njengommeli wakho aye awathola nge-30 zikaMarch, kodwa wena naye nikwazi ukukhuluma ngale statement lezo ngesuku elidlulileyo ngisho izolo phela. So lesi sikhathi lesi asanele ngokuba nidinga isikhathi ukwazi ukuthi nilungiselele i-defense yenu noma ukuzivikela kwenu inkulumo enizoyisondeza la enkantolo mayelana namaqala omangalelwa ngawo. Uthi ngokunjalo-ke kudingeka ukuthi kube nolwazi oluthile okumele ukuthi liverifayiwe kakhulukazi kibo labofakazi okuthiwa ngebembuso labo. Labofakazi laba abanye babo baseGoli, abanye babo baseThekwini, iKZN. So ngokunjalo-ke isikhathi siyadingeka ukuthi-ke bona lofakazi laba bake ba-verify ukukhulunyiswane nabo mayelana lokho abakubhalile kule statement ezinikezwe ummeli wabo. Sesenami inkosi yami. Uthi futhi-ke uma inkosi yenkantolo ingavumi ukuthi wena unikezwe leli thuba lokuthi-ke nikwazi ukuhlolisisa le statement, wena-ke uzosafa lento okuthiwa ngesilungu i-prejudice. Ngamanye amagama-ke uyothola ukuthi ehlangothini lakho kuba khona ukuhlukumezeka kwakho enkambisweni yezomthetho ukuthi awunikezwanga isikhathi esihle esilingene sokuthi ukwazi ukuzilungiselela. Uthi kakhulukazi okusemqoka ukuthi wena naye nikwazi ukulungisa lento okuthiwa ngesilungu kuthiwa i-plea explanation yenu, yinkulumo lo ozoyisondeza la enkantolo uma-ke sowubekwa amaqala ngomthetho. Ngizwisa nkosi yami. So-ke kubalulekile-ke ukuthi-ke nihambe nithola abantu nikhulume nabo ngokuba lokho kuzoncedisa kakhulu ukuthi i-plea explanation yakho nenkulumo yakho ukuzivikela yakho ukuthi ikwazi ukuhlala ngendlela efaneleyo. Uthi kakhulukazi makaqaphuna uthi lapha ku-section 87 ye-criminal procedure iyakuvumela lokho, yize ngeke athinte kakhulu kile. Uthi futhi mawubhekana neqala leli leka-State versus Shabalala kuye kwavela kakhulu kule sahlelo lesavela lapho ukuthi-ke ummangalela noma umsolwa kumele anikezwe ithuba lokuthi akwazi ukuthi azilungiselele ukuqula kweqala lakhe, athole lento okuthiwa ama-further particulars, athole yonke information yahambisana neqala lelo. Kodwa-ke kuleli hlangothi lesikhuluma ngalo kwamanje kuleli qala leli umbuso awukwenzanga lokho ngokubabheka lama-statement esikhuluma ngawo. Yena njengommeli wakho wathole ngedethi ukwazi kuphela ukuthi akhulumisane nawo ngazo nini ngizona uyamzisa baba. So ngokunjalo uthi uyaqela-ke ukuthi lenkosi yenkantolo-ke leliqala mayelihlehlise ngamalanga ayisihlanu, 5 working days, amalanga enkantolo ukuthi nikwazi ukuthola labofakazi nikhulumisane nabo nilungise inkulumo enizozivikela ngayo, then bese niyaphinda niyabuya la nge-21. Then-ke lapho-ke seziqala ziyaduka sekuyasebenza. Ngizwile nkosi yami.
Advocate Baloyi is going to respond, but it might be prudent to hear the other parties first, to hear Advocate Tefo on behalf of accused number 1 to 4.
As it pleases the court, Your Lordship, I think I was amenable for my learned colleague Advocate Baloyi to respond, because I'm not going to respond to or support what my learned colleague said, accused number 5. I've got a clear, straightforward mandate that I've been given from yesterday. So I can come after Advocate Baloyi, Your Lordship, if it's in order. And before, can I be allowed also to approach my client?
Yes. Advocate Baloyi.
I see that my learned friends are still busy. Must I proceed, my lord?
Advocate Tefo, is it still about the request?
I mean, thanks for inviting me. I'm okay. It's my time. Can I respond?
Yeah.
As it please the court, Your Lordship. Firstly, thanks for the indulgence for yesterday. We did consult to our satisfaction. Like I said, I'm not going to comment about the situation of accused number 5. Myself, Your Lordship, I've been given a clear mandate without any ambiguity that my client, accused number 1 to 4, they had a question that I cannot answer, but the state can answer the question. By so saying, they are requesting the state to put the charges on them because they are not aware or they don't know why they are here. And then we will plead, then we take it there from there, Your Lordship. I'm not going to say much until, as per the instruction, the charges have been put to my client and the pleading has been entered into. Thank you.
Yes, except that it's a very strange request because they are here, they've been brought here, they were arrested, they are here, you are their legal representative, you know what happens if you get arrested and you are brought to court. You don't need to request. When due time arrives, the charge is put and you respond to it.
Yeah,
that happens to every accused person who appears before court.
That was the request of the layperson, Your Lordship. Hence, I'll say I'm here.
That is why the layperson didn't come alone.
Yes.
That is why the layperson came with a person who went to school for years.
Yes.
And then went to further schools
Definitely.
to be taught how to respond to these situations.
Mm-hmm. So my instruction, Your Lordship, in short, is that my client need that the state put the charges on them and they plead.
Yeah.
That only that I have a license to take it further as per the mandate. Thank you, Your Lordship. I think I'm clear.
Advocate Baloy, I think this latest request doesn't need to be put to you. I mean, it's your job. You get paid for putting charges to people and so forth.
Indeed, my lord.
Yeah, but there is a request by accused number 5 through the legal representative.
My lord, the simple fact of the matter is accused number 5, and I'm saying this with the greatest of respect, they came to court not prepared. They should have just, from the outset, signaled their intention to request for a postponement because they haven't prepared, instead of just latching onto the late disclosure of the affidavits. On Friday, my lord, your honorable registrar circulated a voice message from accused number 5's legal representative, wherein already at that stage, and that was even before yesterday's consultation with the client, signaled their intention to request that the case stand down for about a week. And this is precisely what they are requesting today. So already on Friday, even before yesterday's consultation, they were desirous of applying for a postponement. And I think if they simply took the court in their confidence and said, we're not ready, we're going to ask for a postponement, I think, no one can really, quibble with it. But I think just to latch on to one aspect, and what I found preposterous, my lord, is they require 5 days. It's beyond me how you can consult with witnesses in Durban and Johannesburg, in a matter of 5 days. What is even more preposterous, they say they're still going to request for further particulars. I mean, how can you come to court after 5 days and be ready to enter a plea, but yet at the same time indicate that you still require further and better particulars? And
if they were to request for further particulars, because I don't think I'm going beyond 5 days, if I end up agreeing to the 5 days, I don't think I'm going to be amenable to any further time for any further particulars. The reality of this matter is that we have 5 accused persons who are entitled to their constitutional rights as outlined in the Constitution. I don't have to go up over that again, we all know. But the other reality is that there is a family of the deceased. This incident issue in this case happened way back, and that family also has rights to know what happened and to know the consequences of what happened from a legal point of view.
Indeed, my lord.
So whilst we speak rights, we should not talk about rights as if there is only one group of people that has rights.
Indeed, my lord. Even the South African public, this was a soccer icon, and everybody wants to know what happened to the deceased.
Yes.
So it's
So-
the
so-
family
so-
and the South
so-
African population at large.
So it will help if clarity is attained around the fact that it will not be a one-way direction in respecting rights. In any case, from the day a police officer knocks on my door and states that he or she is not going to leave me behind, but will take me and arrest me. From that day, I already know that I will need 1, 2, 3 in terms of my defense.
Yes.
So it's not like this thing came out of the woods last week or what, whenever is the recent past that might be cited. But from day one when arrest happens, we know that you have to consider your defense, and that applies to the accused. So beyond the 5 days, I mean, I haven't decided about the 5 days as yet, but I don't think for any reason, for any thinkable or unthinkable reason, we have to think beyond 5 days. That's why I'm asking if further particulars were to be required, would you be in a position to furnish them?
Yes. We just a phone call away, my lord. If they were just to knock off an email to us and say, this is what we need, we'll finish that without any further delay. And my learned friend knows, we've been at the round table. We indicated that there are certain witnesses whose statements, will be withheld. On the indictment, on the list of witnesses, we've also indicated that. And on Friday, I sent them the framework of the presentation of the state case, and I indicated that this evidence will come almost at the end of the state case, months from now.
But can you and me confidently dispute
yes,
the fact that the statements that were released recently could have evoked a need for further particulars on the side of the defense? Can we with certainty dispute that?
Well, they're sitting with the whole case docket. It's not just those statements. But the whole conspectus of the of the state case, and
No, about the whole of the docket. That could easily have happened. If it didn't happen earlier, it would have been the doing of the defense. But where it regards the statements that were released 2 weeks back that we spoke about at length yesterday, can we confidently say it is unfounded that a need arose for the defense to obtain further information and to verify certain facts in order to prepare a defense?
No, we're not disputing that, my lord. All that we're saying is that this statement will be relevant much later in the trial, but they're saying they need that to enter.
I think there
a
you are diametrically opposed in terms of approach, because
yes,
they are saying that they need that information
yes,
so that they can, from the onset, from the beginning of the trial, have that in mind and attain that for purposes of their own knowledge.
Yes.
Remember, one other rule of evidence is that the court at a later stage will be bound to consider the entirety of the evidence in the case, including what one says in plea, in pleading to the charge. So for me, it's a situation where I cannot say that you don't need this because the witnesses will come later and the statements will feature later. But if it's one case involving one deceased person and the incident happened on one day, it is not unthinkable that everything is interwoven so that when a person responds to whatever, it might benefit one to have in mind everything that is involved.
Yes. My Lord, as I said, we're not disputing that. All that we're saying is, one wonders why the disclosure of the statement, will be such that it needs, a whole new, different approach to, to the case. But I've already indicated yesterday, my Lord, that the state went out of its way to, to provide the statements as soon as possible. When I traveled to Durban for consultations, I took the statements personally and I handed it to them personally, and with a view to ensuring that we can proceed with the with the trial. But be that as it may, my Lord, we just request that they be put on terms, as the court has already indicated. If they need any further particulars, that they should do so before the the next date of postponement, so that we don't sit in the same situation. One cannot really express one's displeasure sufficiently, at this state of affairs. At some point or the other, this trial must get underway, and we just hope, my Lord, that should the court be inclined to exercise its discretion to grant the postponement, that at least at the next court appearance that we can get on with this case. Thank you, my Lord.
Advocate Mchololo.
What business, my Lord?
Two things. The first is, do we really need 5 days? We're talking here one accused person. I do understand you did say that some of the consultations have to happen in KZN, whilst some have to happen here. Do we need 5 days for that?
My Lord,
because it sounds like it would have needed 2 days.
My Lord,
one wonders why you are stretching it to 5 days.
In response, my Lord, to that, these statements, my Lord, were obtained on the 27th of July 2020. The state has been sitting with these statements from 2020.
Do we go back to that? I think we fleshed that out yesterday, the reasons why. I don't want them repeated. I don't want to throw that issue the way of the state, because that has been explained over and over and over again. It has to do with security issues. And you and me know, as we are here, that security issues for witnesses, indeed for everyone that features in any court in our land, have become more than an issue. So Advocate Baloyi explained yesterday that the timing of the release of the statements has to do with the safety of the witnesses. So the naked question I'm asking you is whether we really need 5 days. I said that's number one. Number two, it's not even a question. I have already stated that beyond the statements we are dealing with, possibilities of further particulars that you hinted at, I think I would be very, very reluctant to even consider any other delay to the start of the trial. Your comment.
Thank you, my lord. My lord, the problem we are sitting with or we are facing now has been caused by the state.
You are repeating that?
I have consulted with my client yesterday,
Yes.
and it has transpired that we need more time to prepare our case. As a result,
The reason why I'm already talking 2 days instead of 5 days is because I've already considered that you need more time.
yes, my lord.
The only question there is on the table is as to why you need 5 days, where I would have thought that 2 days can do that. That's the only question.
My lord, if that means that I have to repeat what I have stated before this honorable court, that from the information that is contained in the statement, it transpired that we need to consult with the defense witnesses, some of them who are in this division and some of them who are not in this division.
Yeah.
That I cannot anticipate to happen overnight.
Yes.
Hence, I am seeking for indulgence to be afforded with adequate time to
Yeah.
prepare our case.
Yeah.
My lord, the question to say whether 5 days is enough, it is not enough, my lord. However, we're going to try our best. Because we have been given limited time, my lord. Seeing that the trial has already started, we have to push and we have to work fast so that we make sure that you are able to come back ready to resume with this trial. All we are asking, my lord, is to say 1 day was insufficient, and we therefore ask for another 5 days. And it is not correct for the counsel for the state to say that time it's too much, because he is not the one who is representing my client. I am the one who knows what needs to be requested, what needs to be done. And it is done it is suggested by the defense at the expense of the violation of my client's constitutional rights. They are the ones who decided to withhold the statement. They are the ones who now are telling this court that we are applying for the adjournment because of the delaying tactics. That's an insult on our side. Had we been given these statements, my lord, a month ago at least, we would have been in a better position today, my lord. We wouldn't have been troubling this court.
I think you will be in a better position. But in the reasoning of the state, everybody, including the whole nation, will be in a worse position without witnesses, with witnesses 6 feet under. So that better is very relative. It depends on where you stand.
That's the problem, my lord, that I'm representing my client's constitutional rights.
Yes.
Yes.
Yeah. So for you, it doesn't matter who lives and who dies.
No, it's
For
not
the
like
state,
that, my lord.
it does. That is the reality of the matter.
That's not what you are saying, my lord.
No. They are telling you clearly there are security issues around the witnesses. And you are repeating the statements should have come earlier. And they are saying from yesterday, we were still organizing a program, a witness program for the safety of the witnesses.
Yes, my lord.
And you keep on repeating what you are saying as if you didn't hear that. But I have heard it.
As the court pleases, my lord.
So that's why the better is very, very relative. It depends on where you stand.
As the court pleases.
I think indeed, if I were an accused person and I hear of a funeral of a witness, of a potential witness, better would be the word to use.
As the court pleases. My lord, I think I have answered the questions put to me by his lordship.
Yes. Okay. I think you have. Other than that, you were taking us back about the issues of the safety of the witnesses. You have explained that 2 days would not be sufficient.
Yes, my lord.
Yeah. The second part I raised to you,
Yes, my lord.
actually to everyone, putting everyone to terms, is that beyond the 5 days, we need to start with the trial.
I agree, my lord.
Anything else to say, Mr. Baloy?
Nothing else. Thank you, my lord. If the court is inclined to grant the postponement, I don't know if we haven't agreed on the date.
We spoke about 5 days.
Finance indicate that he wants to say something.
Yes.
Thank you, Lordship. As it please the court, I was definitely reluctant to be part of this going on discussion or argument or submissions. As accused number 1 to 4, we are definitely taken by the surprise by the submissions of my learned colleague, accused number 5. The mandate that have been given by accused number 1 to 5, actually in this matter, if we have to talk about the proportionality, majority here. So I will see the majority being prejudiced by the minority. Which
Mr. Tefo.
Can the court allow me? Your Lordship.
So in your court, majority rules.
In my court, majority rules, and the need of the minority, there should be exceptional circumstances.
Let's not indulge in that argument. I think you will have to go and write your thesis and convince everyone to go and even rewrite the Constitution to say majority rules in court.
In a serious note, Your Lordship.
Let us not spend time on that because it is not here yet.
Yes. Okay. The Honorable Court is aware that from yesterday in the Honorable Chambers that I've indicated that I was vehemently in opposition of any attempt to postpone this matter. It was on the 17th of March this year.
Why are you going back to yesterday? Yesterday was stretched out.
History is very important, Your Lordship.
No.
They say know your history before you can know your God.
No. History is important if people have forgotten it. But are you saying that I forgot what was said yesterday?
It was not you who was there, Your Lordship. And I'm not saying this with a disrespect. I'm saying this with a very serious concern, and I'm also in support of the words of the bench of the Honorable Court when say that this matter.
Are you saying that this debate was already discussed, decided upon by another judge? Is that what you are saying?
I'm referring to the court that I'm facing now. That when the court was saying, in the best interest, because here I can say my client, accused 1 to 4, they are requesting nothing but expeditious justice to be dealt with. Because I see here my learned colleague, accused number 5, with a due respect, is using this court's time, because we are supposed to have started yesterday, is using this court's time now to get into or to involve this court behind the back door with the pre-trial issues. So until such time, Your Lordship, the charges have been put to the client. In particular, I'm talking about my client here, 1 to 4. They don't know what they are here for. And as you said that, educated person has been called upon to speak, to be their mouthpiece. And I'm here, and I'm that mouthpiece. And I say, if there can be any postponement in this matter today, they will be seriously prejudiced. And it will be a very sad day in the jurisprudence of this country that if we are going to entertain certain issues, that if we have to put them on the scale, the fulcrum will not reach the equilibriumity. You see, there's no equilibriumity here, Your Lordship. So the interest of the state, for which my learned colleague has indicated, desired that this trial has to proceed, has to start, insofar as yesterday. So any engagement here is of no use to anybody here. That's my submission, Your Lordship. And furthermore, not in a lighter, but in a very serious way, because I was trying by all means that my birthday should not be spoiled by the situation here. Thank you. Further to that, I'm sorry. Section 87 of the CPA. I want to read to the record for this court in relation to responding to my learned colleague, accused number 5. May I proceed, Your Lordship?
Yes.
The court may order delivery of particulars because it has been talked about the delivery of the particulars. Which?
Why are you reading that part? Because he has already said he is willing and ready. He said anytime he will deliver further particulars.
All right.
So why do we need that debate?
This debate is just in terms of one line to confirm him. Because remember, Your Lordship,
why do you need to confirm something that is not even doubted? I mean,
if it's that
everyone agrees that there is a need for further particulars. He has said, even if they call him in the night, he will furnish further particulars.
Yes, I read this in my context. The court would remember that.
No, Mr. Tefo.
In my context is that my client, Your Lordship.
No, I don't. I think if you want to revise that section, go and revise it at home.
Thank you, my Lordship. I'm unable to.
Yes.
That. Thank you.
Having listened to all parties and considering that there is the reality of statements that were released recently, statements about which the legal representative of accused number 5 has a complaint, in the sense that accused number 5 found himself without adequate time to prepare a defense around issues that emanate from the statements. The court rules that it shall grant the request for a further postponement. There was a debate around days over which the further postponement should happen. The representative of accused number 5 states that because the witnesses to be consulted and the further particulars to be obtained have to be obtained from KwaZulu-Natal and Gauteng, 5 days are needed. The state is not necessarily opposed to that. Advocate, therefore, by virtue of the mandate from his clients, being accused number 1 to 4, is vehemently opposed to any prospects of a further postponement. The court, having considered all of that, and having considered the constitutional rights of everyone to be put in a position to prepare a proper defense and an adequate defense, the court rules that it grants the request for further postponement. The court also, in a way, put the representative of accused number 5 to terms to say that this should be the last time that this case sees a postponement. And therefore, this case is postponed. This case is postponed with the accused in custody. It is postponed over 5 days, and that takes us to what date, by the way?
Let me double check, my lord.
I think maybe my learned friend should rather
It's
give the date.
my lord, the 5th day from tomorrow, 5th working day will be until the 21st
Yes.
of April. So we can come back on the 22nd.
Yes. So this case is postponed with all the accused in custody to the 22nd of April 2022.
That's the court decision.
My lord, just two quick aspects.
Yeah. Before that, let's agree about the time to start.
Yes.
In the morning.
I think with us 9 o'clock is fine, my lord.
9 o'clock.
It's fine. It's suitable, my lord.
Can we start at 9?
Lordship, I'm coming from Johannesburg. 10 o'clock is fine.
Come again.
10 o'clock. Amended date.
Can't we make it 9:30?
9:30 is fine.
We'll start at 9:30.
As the court please, my lord, just one aspect. I see that the 22nd it's a Friday. I don't know whether it's feasible to start with the trial on a Friday. That is the first aspect. The second aspect is the court asked me yesterday to look into the possibility of having the accused detained at one facility.
Yeah.
We've taken this up with correctional services, and they've written a letter. It comes from the regional head of correctional services, wherein they indicate that due to security reasons, they say it is unfortunately not possible to incarcerate all the suspects at one specific correctional center, and they cite risk factors and logistical arrangements during transportation. That would mean that the accused number 1 will then be detained at Moda B in Benoni, accused number 2 at Khosi Mampuru, as well as accused number 3.
Like we decided yesterday?
Yes, and 4 and 5 at Lukop.
Okay.
As the court, Your Lordship, in regard to accused number 3, Mr. Ngube, he said Khosi Mampuru. Then there is a concern that he has to raise. Is kept at a maximum, where he does not have any line of communication with the relative. So he need to be taken to New Lock instead of a maximum. Because initially he was at Johannesburg prison, where he was also taken and be transferred in violation of Section 43 of the Correctional Services Act, whereby before the transfer of any inmate to another prison, he has to be checked by the medical practitioner or the medical practitioner. So those did not happen. So the request is that he be now transferred to New Lock. Thank you.
Mr. Baloy, I think we will need another response from correctional services regarding accused number 3. You had the concerns raised. Can you take the matter up with correctional services? I did say, like yesterday, I'm not going to make orders against correctional services. They know best what are the issues. When they say security issues, when they say logistical issues, they are talking about things I do not know about. So I don't want to make orders from the bench out of ignorance of all those issues. So if you take that up, so that when next we meet, you should have informative inputs to make around why accused number 3 is being kept under the conditions he is complaining about.
As the court pleases.
Because I think pre-trial incarceration should not be allowed to be punitive in nature. It should only be allowed to serve the purpose of ensuring the presence of an accused before court. But beyond that, there are security issues that correctional services will know about. I think SABC will also know about those issues better.
As the court pleases.
I'm sorry, Lord, to bring very serious issues in piecemeal. Yes, still pertaining to accused number 3. Is requesting that your Lordship or the court have the 2 assessors, is what is requesting from his defense. That the court be requested that
that's a pre-trial issue. That's a pre-trial issue. Why are you raising it here?
Yes, I came in this matter on the 17th of March.
No, I don't want it to appear as if the court sourced assessors. If that is an issue, take it up with the state, take it up with a colleague, and then come back to me with regard to the agreement or the lack of agreement that you will have attained.
Yes, I'm raising this because I was not part of the previous pre-trial with the accused 5 and other. Previously, it was Judy Care from the legal aid.
No, take it
I'll do that.
Take it up with your colleagues.
Thank you.
Anything else?
Nothing more, my lord.
Sama-sama, Ustaz. Sabu wa muslim.